Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy, and today we will be evaluating a document that was filed on February 21st, 2023 by the state of Idaho, and it is the state's response to the defendant's first supplemental request for discovery. Now, also on February 21st, 2023, which is directly relevant to this response, an order was entered by the court stating that Exhibit A to the defendant's first supplemental request for discovery that had been filed, ladies and gentlemen, on the 3rd of February was to remain under seal. So we don't know what Exhibit A states because it's filed under seal and it is not in the public domain. And that is problematic if you would like to learn what is being requested and what's being responded to in discovery, because Exhibit A is listed all of the additional discovery requests that the defense was making in that supplemental request for discovery. So we don't know what was asked for, and in a way we don't know what's being responded to here because Exhibit A is under seal. In any event, on the 21st of February 2023, Mr. Thompson came forward. He signed and filed this response. And what he basically is saying here in this brief response is we incorporate and state herein, as if by reference, the original January 23rd, 2023 responses to the original discovery requests. So in a nutshell, what he's saying is we're responding with documents that we already produced to your first supplemental request for discovery, and specifically to Exhibit A. Everything that we've produced before, we're now producing. The problem here is we don't know what was produced before, because if you look at the original responses to discovery, they refer to an exhibit, and that exhibit merely provides a description of the bait stamps of photographs and video and documents, but it doesn't provide any details of what those documents are or what they say, what those photographs depict, or what the video is of. But in any event, we see the state here on the 21st of February responding with the documents and things that had already been produced. But the state does go on and say that the state has and the state will continue to provide discovery in accordance with Idaho Criminal Rule 16 and applicable law. And basically what they're saying here is that we've produced everything that's responsive to your discovery request. However, if we come into something else that's responsive to a discovery request that you made in January or you made in February, in these cases here, let's say they come into possession of something in March or in April or in July, they have a duty to turn it over, and they say that they will turn it over. They don't have to wait now for the defendant to make another request for the same things. So as we continue to look at this case, and as I stated, my reasoning for presenting this series is my personal opinion, which I continue to exercise under the First Amendment, that much of this case is beyond the public realm, that we know so few facts, we are privy to so little evidence, in fact, little to no evidence that the state has, that it is unclear why Mr. Kohberger was charged at this point. We have an affidavit of probable cause, we have various statements, but that's not evidence. The evidence is this discovery that they keep asking for, and they say that they're turning over. That's my opinion. I thank you very much for joining us today here at the Indie Zone, and I hope that you will join us again.